Hi friends from around the world. This is about the works definition, about the definition of copyright by the European Union Court of Justice. And there are two cases, or three cases if you want, about that, which defines a bit more what is a copyright. So we know, or we talk about static value, we talk about, the originality of the work, we talk about the representation of the work, but we don't know exactly what the European notion of works is. And again, I will repeat until you get to have it in your brain. There's no European title, it is a national title, meaning that enforcement normally has to be done through national courts, and it will come only to the European Court of Justice if European law is involved first, and second, if it is referred to the European Court by national courts, right? Now, it is not a European copyright, but it is European law through the Harmonization Directive here on the screen, the Copyright Directive. And the Copyright Directive gives the mandate to member states to transpose its requirements, minimum requirements, into national law, and then national member states may be possible that they get beyond that minimal requirements, but the minimal requirements must be met. So this is about the Copyright Directive, and we have 2A Copyright Directive here on the screen, which means it must be a work. And that is all what the European law says. It is not only mentioned, works is not only mentioned in Article 2A, it is mentioned also in other articles of the Copyright Directive, meaning that the European Court, they took it up as a European law and one notion which must comply with all, that notion must be interpreted uniformly across the European Union. So let's come to the first case of 2018. It is about taste of cheese. And if you know something about Europe, you know cheese, that must be something from France or from the Netherlands. And in fact, it is from the Netherlands. And we have two, and it confronts two companies of the Netherlands making cheese. The one is the Lengelo company, who produces a kind of cheese with herbs which have a special taste. And it worked well, so they are merchandising it, or not merchandising, that's selling it on the market for some time. And they have also a patent on the manufacturing process for that kind of cheese. And I don't know whether an employee of that company was the one who invented it or somebody else, which was then outbought by Lengelo. In any case, that was first kind of monetization of a patent and a copyright, because if it has not sold to Lengelo would not have any copyright, right? So it would remain with the author, so to say. Now, this was Lengelo, and there's another company, Smilde, who also makes some kind of cheese, and it was sold in supermarket chain in the Netherlands. Now, Lengelo was suing the Smilde company in the Dutch court over infringement of its copyright. So not on the patent, but on the copyright side. And they said the taste of the cheese is copyrightable, and it is its copyright, and so this is infringing by Smilde. Now, they went in court, and the first court, they rejected it. The second court as well, and goes up to the Superior Court of the Netherlands. And there we are with some doubts from the part of the Dutch court by saying, well, there are two things. One is the superior Dutch court, which admitted a perfume, a scent of Lancôme as a copyright. And we have, on the other hand, the French Cour de Cassation, also a high court in France, which put in place the contrary decision. They did not admit as copyrightable the scent of a perfume. So in the case that we have two divergent case law from different countries, but from high-level courts, so they were not clear what work is in the sense of Article 2A, if a taste which is comparable according to that court with regard to scent, if a taste can be a copyrightable work, so to say, in the sense of 2A of the Copyright Directive. Now, it went to the Court of Justice. In the Court of Justice, they made clear that the work is something which needs originality on one hand and needs to be representable on justifiable, identifiable, and representable on the other hand. Now, this goes the second part here. The one of the representation, it must be identifiable and precise, sufficiently precise, so that goes in the sense that the scope of protection must be clear to other parties. So if it cannot be represented, then other parties, they don't know exactly what is the scope of that protection, right? This goes to the notion of fixation of copyright. So it must be fixed, it must be represented into something. Like a sculpture, well, that is the stone, the marble, right? Or the literary work, that is the book, the letters, the alphabet. Or what is the music? That is the sound notes, right? So it must be representable. And here as well, they said, well, so it is to take out subjectivity out of the equation. So it must be objective so that everybody has the same view on this issue. And the taste of something is, per definition, according to the court, subjective. Meaning that according to age, preferences, to habits, to tastes, if you want, the people have a different perception of what is that taste, that certain taste. That would be probably the same with a perfume. In the end, what is the outcome of the case is rather that any subjectivity must be placed outside the equation, so to say, and the second notion or the second condition for a copyrightable work under 2A of the Copyright Directive, it must be representable in an objective manner, and this is not the case. So this is not being the case for the taste of cheese. It was called Which Cheese, that one from Lengelo. So they clearly decided that is not a copyrightable work. So this comes a bit in the fixation or representation with regard to trademark pundits among you. So representation was a kind of, well, in trademarks must be represented. So it must be seen by everybody so that they can see the scope of protection of that trademark and be clear, well, I'm not infringing, I'm doing this, I'm doing that, and this is something different what I'm seeing on the registry. So this is one case. Let's come to a second case from 2019 here on the screen. It is a Portuguese case. So we have two Portuguese companies involved. The first is G Star. So both on the clothing sector, right? G-Star. G-Star made jeans and T-shirts for a certain time, and they were on the market and sold, etc. And then there was a second company, Cofermel from Portugal, who also are in the clothing sector and made T-shirts and jeans, among others. And the G-Star said, well, these were infringing goods, what Cofermel made, placed on the market. And they sued in court for what? Not for design rights, but for copyrights. So the first was either patent or copyright, and they choose the patent to enforce, the copyright to enforce. And here we have design rights, probably, and we have the copyright, and again it was chosen the copyright to enforce against Cofermel in that case. Now, shortly briefed on that case, it is that it came to the Superior Court of Portugal and then to the European Court of Justice. And it is about the aesthetic value. So the Portuguese court was not clear, is that necessary to have an aesthetic value, to have something of the creativity, to have this something, it must be seen as something, which is original, creative, aesthetic, which has a value, which gives something an added value to something. So this was a bit the question which was posed by the Portuguese Superior Court to the Court of Justice. And the Court of Justice, in its judgment in 2019, they said now clearly, and it comes from a very much earlier decision of the European Court of Justice from Infopaq in 2009, here on the screen, that, it was now precised a bit better, that we need two conditions in order to be fulfilled, for that something is qualifying for a copyrighted work in Article 2A of the Copyright Directive. The first is it must be original work, an original work from a creator, from an author, from a person. It is, the thing with the artificial intelligence is something different. I go to it in a different, that merits a different video. But here, it must be something original. Now, what is about the aesthetic value? Well, here we come again a bit into what we have seen in the previous court ruling. The court wants to avoid any subjectivity to come into the equation. They do not rely on subjectivity, and I can understand it. We want to make sure that everybody knows exactly what is the scope of protection. Otherwise, if subjectivity come into place, I think this is, I have another opinion. My opinion is that, that is opinion, right? So you cannot base what is the case law on certain opinions which have preferences of one person, or the taste of another person, or the scent of the third person. Now, the originality is required. Aesthetic value is not required. So there must not be an aesthetic requirement be fulfilled. And the second part, the second condition, so to say, is the requirement of identifiable, justifiable. So it must be represented in a way that everybody can understand it. So again, a bit about the fixation. So this is the 2 or 3 cases you may want to get deeper if you are in the copyright business. You may read them all. They are very much, what is about on the heart of what is the copyright in Europe, and all the member states must require that. That is a minimum standard which which is to be complied with. Two conditions, I repeat it. The one is the originality of the work. So it must be something new and something, something original from the author, expression of its personality, so to say. And second, it must be identifiable. Identifiable in the sense of fixation. It must be represented so that the scope of protection can be assessed by anybody in more or less the same way.